All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. We will hear argument in 3 cases this morning. The first is 240425 Equinor Energy versus Lindale Pipeline, from Harris County and the First Court of Appeals. The second case is 240525 S&B Engineers and Constructors and Zurich American Insurance versus Scallon Controls from Jefferson County and the Ninth Court of Appeals. And the third case is 250008 in re CS and ZS from Taylor County and the 11th Court of Appeals. The court has allotted 20 minutes to each side in each of the cases. We'll take a short break in between the arguments, which can be viewed online and will be available on the court's website later today. We are ready for argument in case number 240425 Equinor Energy versus Lindale Pipeline.
May it please the court. Mr. Smith will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Your Honors, and may it please the court. The text of the pipeline agreement demonstrates that it was Equinor's predecessor that built and owned the pipeline. Because it was Brigham that built the pipeline, Lindale had to contract for the right to use it. It is undisputed that Equinor honored that agreement, allowing Lindale to use the pipeline infrastructure. There was no promise giving Lindale the exclusive right to provide water to Equinor's wells. I plan to discuss the text of the contract, followed by the applicable law regarding requirements agreements, and finally a brief word on damages. Starting with the text of the agreement, the core language is the second paragraph of Section 4 of the pipeline agreement. That's in tab B of the bench exhibits. That is the language that the trial judge delegated to the jury for interpretation, and that is the sole language that they made a breach finding with respect to regarding their exclusive ownership theory.
Let me ask you, so, it seemed after reviewing all of this that at the time, which was a long time, relatively speaking, this alternative way to get the water to where it needed to be to help get the stuff out of the ground was an efficient way to do it. And so because of that, the water company, Lindale, they decided that they would go to the trouble and whatever to do this through this way. And nobody was anticipating that in the future there would be a new method that would be much more efficient, right? And so does that have anything to do with this?
No, Your Honor. An expectation is not a promise. And if we look at the express text of the second paragraph of Section 4, it has the answer to your question. Because Lindale did not own the pipeline, it had to bargain and contract for the right to use it. And I want to walk through the text of this specific clause, the one that the jury found a breach of, and then tie it to the rest of Section 4, and then tie it to the rest of the contract as a whole. Now, Lindale shall be the sole and exclusive water provider and pumper on the pipeline. Let's walk backwards through that, because the phrase pumper on the pipeline holds a key to the rest of the text. If you look at tab C, you can see what it means to be a pumper on the pipeline. It is there are physical pumps located on the physical pipeline infrastructure. and Lindale is the one who is pumping the water through the pipe. Lindale does not claim to have been, and the contract does not make it, the exclusive pumper for wells. If you look at the quote from Lindale's owner, he acknowledges it is a third-party company that is pumping the water into wells for fracking purposes. Again, the promise of being pumper on the pipeline is referring to the pipe, not to wells. And that's the key, because Lindale, the text should not be interpreted to make Lindale the exclusive provider of water to the very wells that everyone agrees Lindale.
So if you're right, if we agree with you on that, and this agreement as far as exclusivity really dealt with the pipeline, if water is getting to the wells that way, and it's not saying anything about other ways to get there, then did they suffer loss anyway, though?
Did Lindale suffer? Well, in the same way that Brigham and Equinor, which had invested $13.5 million in the pipeline, you can see that in paragraph 1A of the agreement, Brigham had to walk away and see that its investment had become obsolete due to changes in technology. And Lindale suffers the same thing, but it wants to turn us into a guarantor or a shelter against changes in the market. And promises like that are stiff medicine, strong medicine. There is a way to make an agreement like that. You can promise to be the exclusive provider for wells. That's not what this agreement says.
In the first paragraph, what is a well site? So the pipeline is defined in the first paragraph of the contract, and it includes well site appurtenances. What is a well site appurtenance, and how is that different from a well?
So an appurtenance is akin to a fixture, something that is there and built to be attached to the property and carried with the property. The wellhead itself is separate and distinct from the well site appurtenance. That's why it says well site appurtenance rather than well. And if you
help me, what sort of fixtures are you talking about? So, and then how is it different from the wellhead?
Yeah, maybe you have the permanent water storage tanks on site. Maybe you have other things attached to those permanent tanks. But the key is that when third parties provided water to the wells, they were not using Equinor's well site appurtenances. They were not using it.
How do we know that from an engineering perspective? I mean, if you've got a pipe that's coming from the pipeline going into the wellhead and the pieces of metal that are on top of it, you can maybe explain this better, but is there at any point were the lay flat pipelines coming into a piece of pipe that was put there by Lindale?
No, Your Honor. If you look at volume 9 of the record at page 77, the testimony is that the frac crews, and these are third-party contractors, not Equinor's employees themselves, that they are attaching their water supply directly to the wellhead. And if you look then at volume 6, pages 261 through 262 of the record, you'll see that they are temporary water tanks used for the fracking purposes that are separate and distinct from any permanent fixtures or appurtenances at the well site. The testimony is that if you look at pages 77 and 78 of volume 9, it is that this water is not going through the pipeline. It is completely separate. These are above ground water hoses akin to a giant fireman's hose.
Right, but my question was how it gets into the well and whether the pipes sort of cross each other or how that.
There is no evidence of that. That's not
okay.
Correct.
What about paragraph or section 1A includes this sentence: Brigham hereby grants Lindale the exclusive right to operate and maintain the pipeline in order to provide water for drilling, completion, and production operations. Why isn't one reasonable reading of that sentence that Lindale has an exclusive right for to do these things with the pipeline, which will be providing the water for the operations.
There's a difference between the purpose and the promise. And no,
Well, that
two
says
things.
grants.
Well,
so that's not just a purpose.
So two things about that. First, the jury's breach finding is limited to the second paragraph of section 4.
But you'd agree we have to read the whole contract in context.
That's correct. The second is that it does not say in order to provide all water for all drilling, completion, and production operations. There'd be a
But it doesn't say some water for some drilling either. So that's why I'm asking it, why is not one reasonable reading that the exclusive right of the pipeline is to provide the water for the drilling and completion operations?
This is Equinor's pipeline, and the purpose is to give Lindale the right to use that infrastructure. And if you look at back at paragraph 4, for the context of how this works, the label to that paragraph is pipeline priority and excess capacity. And the essence of this deal is that because Lindale is using the pipeline that belongs to Equinor, Lindale has to make some concessions in order to do so. The first concession is that Lindale has to prioritize delivering water to Brigham or Equinor when Brigham wants to take it, but that Lindale gets to use all the excess capacity to provide water to third parties. It's the ability to market water to whoever it wants to that is the value of getting the exclusive right to the pipeline. And when we have the defined term pipeline, not including wells, the promise is limited to that. The sole and exclusive language goes hand in hand with excess capacity. It does Lindale no good to be able to use excess capacity to provide water to others if it does not have sole and exclusive rights to the pipeline, such that Equinor could hand the keys to someone else to siphon water away. No, the point is for them to have rights on the pipe. And that ties to the opening language in the agreement. If you look back at tab A, you'll see that Lindale is responsible for getting all necessary pumps to operate the pipeline. They're the pumper. They are responsible for getting water permits. That's because they're the water provider. If you look at tab D, there's an example of the permit that they have. The court knows from American Midstream that sometimes the party that's pumping molecules through the pipe is not the same entity that owns the molecules. The purpose of the phrase provider and pumper is to say Lindale's doing both. But that doesn't give them rights for wells. That could have been stated, but it wasn't, and they disclaimed all extrinsic representations. I want to go back to the point about the nature of pumper. Again, Lindale is not the one pumping the water for the wells. It does not claim to have been the exclusive water pumper for wells. And the contract should not be interpreted to make it the sole and exclusive water provider for the very thing that everyone agrees it could not be the sole and exclusive water pumper for. That is an unreasonable interpretation of the contract. And that goes hand in hand with this court's teachings in PACE, that when there's an obligation for a seller to provide a good or a service, that doesn't imply a reciprocal obligation to take. And we see that Lindale is obligated on this pipeline that belongs to Equinor. It's obligated to provide the water to Brigham, to Equinor, but that does not imply an express promise to take. This is no different than if the newspaper boy gets the sole and exclusive right to deliver newspaper on the route. You can't complain then that news is going through the wires on the internet. There are changes in technology, and unless you have expressly bargained for the strong medicine of a requirements deal, you shouldn't be held to here. millions and millions of dollars of liability for simply doing what is a normal part of participating in the market, buying from someone who offers at the best price.
What do we make of the use of the words on and through in the second paragraph of section 4? So it says, Lindale shall be the sole and exclusive water provider and pumper on the pipeline. However, in the unlikely event that Lindale is unable to provide water through the pipeline for Brigham, Brigham may then use other water sources or pumpers on the pipeline. So presumably, the parties had a meeting of the minds. They chose the words on and through with care. What do we make of the use of those different words?
I think the word through is a throwback to the top of section 4, where it talks about first priority for water delivered through the pipeline. And that's key because the only part of section 4 that talks about water delivery is the first paragraph that creates a right of first refusal, and the second paragraph doesn't turn that right of first refusal into a promise not to refuse. The jury's not allowed to do that. Now, I want to make a brief comment about damages.
But I'm sorry. Normally, we would think that different words were chosen with some reason in mind, and so why say in the second paragraph of section 4 both on and through?
Because the result of being a water provider and pumper is that water is going through. Mm-hmm. So they go hand in hand, but that exception is limited to the capital P pipeline itself. So if you look at tab C, if those pumps fail, if you look at tab D, if the water permits expire, then there's no longer Lindale's water going through the pipe, and Equinor is allowed to have someone else run the physical pipeline itself. But that is not a promise that they can't use completely different infrastructure to provide water to wells.
Would the second paragraph of section 4 mean anything different in your view if instead of saying through, they had said on, in the unlikely event that Lindale is unable to provide water on the pipeline, Brigham may then use other water sources or pumpers on the pipeline?
I think they're synonymous, Your Honor.
Okay.
This court should reverse and render. Thank you.
I wonder if you could say just a brief word about damages.
Yes, so the key point is that it is undisputed that Equinor provided that excess capacity to Lindale. And if you look at tab E, you can see the millions and millions of barrels of water that Lindale derived value from by using that excess capacity to sell water to others. Lindale's position, you can see it on page 53 of their brief, is that the value of the pipeline agreement as received by Lindale was 0. The evidence proves that conclusively to not be correct. They derived value by the sale of water through the excess capacity. In truth, that was the essence of the bargain. So this court should reverse and render. At the least, the damages should be discounted for the value that they did receive.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Keltner will present argument for the respondent.
May it please the court, I'm proud to represent the Amarillo National Bank. We're the assignee of the judgment with Lindale's approval, and I have their approval to make the argument today. I'm assisted by Natasha Bro with Haynes & Boone, who together with Lynn Liberato wrote the briefs that I'm going to argue, which is a new experience for me, but having an overview of a newcomer might be helpful. You all know what the issues are. They're one, damages, which Justice Young just asked about. The other one is the interpretation of sole and exclusive water provider. You didn't hear a whole lot about water provider. You heard a lot about pumping. And I understand their connection, but that's going to be the issue. Now, the court, as you know, decided the contract was ambiguous. With Polyco, that's always a dangerous step for a trial court. We understand that. We argued at the trial court that ours was the only reasonable interpretation. Of course, Equinor did the same. The trial court disagreed. We still think ours is reasonable. And if it is, and they claim theirs is as well, we win two ways. One, with the jury verdict on ambiguity, and two, in contract construction. The only way Equinor...
How do you get around just the phrase "on the pipeline" and the definition of pipeline?
This way. Your Honor, I'm going to go through it in greater detail, but let me directly answer your question now. If you will look, and it's in my handout, it is going to be page 2, sole and exclusive, and this is the second entry, sole and exclusive water provider and pumper on the pipeline. As Justice Sullivan just pointed out, the term "on the pipeline" is only used in this section. This is the only place it's used. And what does it refer to in pipeline? It is not only the definition. If you look back to page 1, which is the first paragraph that was also referred to you, is the following terms have been agreed to with regard to the North Dakota Rough Rider freshwater pipeline project, the pipeline. Then the physical attributes of the pipeline are then defined. Now, in answer to your question, Justice Lehrman, here's what it is. By the way, through the pipeline or delivered through the pipeline is used 8 other times in this agreement. 8 other times. But exclusivity, when we're talking about that, we use "on the pipeline," except for the exception which Justice Sullivan has picked up on. That's an important distinction. Here's why. "On the pipeline" defines the scope of the exclusivity. And in exclusivity provisions, it's always important to know how far the scope goes. So, if it's on the Rough Rider pipeline project, which is what the agreement says, and it deals with water going through, being delivered, we are the sole and exclusive provider. Now, in practicality, the real truth of the matter is all this water is headed towards the wells, and we're going to run through that. But that's the distinction. The terms "through the pipeline" or "delivered through the pipeline" are the functional performance, and those are described separately. Even if you look at Section 4, Paragraph 2, you will see the exception is defined in terms of "through the pipeline," which is the functional performance. If you can't perform, there is an exclusion and someone else can do it. But the scope of the agreement is clear. It is water on the pipeline project, and that is done by definition. This court in Sundown Energy was very careful to say, even if an application of the definition doesn't make sense or the best sense, if the parties have agreed to the definition, and the parties did here, then that issue is conclusive.
Does it seem strange to you that if the real goal is for the wells, and I think the point you just made a minute ago was that inevitably it includes the wells, that we would have a definition of pipeline that is so detailed and granular, but that doesn't say wells?
But it does. And let me explain why. It doesn't actually in the words used, but the reference to the map does. And if you will look...
But I guess my point is, I know that you've constructed an argument that if we connect all of these dots, we get there. But
right.
There's a lot of words that are very express and detailed, and it seems strange that that really, really important word wouldn't be one of them if that was, in fact, what the parties were contemplating.
I'm going to answer that 2 ways. One, by showing you other parts of the agreement that make that clear. But let me also directly respond to your question about the definition. The definition does not mention wells in the actual words in the preamble, but it refers to a map that certainly does show the wells, and it shows them by dots. Everybody agrees with that. Those were wells. Even you see lateral lines going out from the wells. Those are the thin lines, and this is on pages, I believe, 8 and 9 of our brief. That's the part of the project. Now, what was the purpose of all this? And the purpose of the agreement was pretty clear. It was the pipeline was, and this, if you'll look, this is on page 3, purpose of the agreement. This grants Lindale the exclusive right to operate and maintain a pipeline in order to provide water for drilling, completion, and production operations. Of what? Had to be the wells. There was nothing else. That's where all the water would eventually end up.
If
There were-
this was more general as to wells.
Right.
And not specific as to an allocation of resources on the particular pipeline, why does the however clause provide for the use of other sources or pumpers on the pipeline? So on the pipeline is twice in the clause. First, to grant the exclusivity, and then to allow for alternatives should Lindor be unable to provide.
I'm sorry, I was
It
looking
seems like if your construction is the correct one, it would say Brigham may then use other sources or pumpers, period. And that would seem to indicate that we were talking about something larger than just the pipeline.
I think on the pipeline does, by definition, mean the pipeline, freshwater pipeline project, the Rough Rider project. The reason for the difference of using through is it was talking about performance, not scope in that phrase. And I think that's the distinction.
So if Lindale was unable to provide water on the pipeline, Brigham was limited to covering for that by using other sources on the pipeline. It couldn't have decided to bring in fracking pumpers?
No, I'm not so sure that the last phrase modifies that. It certainly does as to pumpers, not so much water providers. We wouldn't go that far, Your Honor. But the truth of the matter is, and I see I've confused you, but what I mean by that
I
is...
confuse myself all the time.
Well, but your confusion is important, mine is not. And so the important thing here, I think, is this. In answer to your question, the parties really did go ahead and provide for the use of other methods of getting water. Paragraph 3 of the agreement, which is in our handout, discusses when you could truck water in. And it was only in the event that the pipeline was not already connected to the wells, and it describes who pays for it that way. So the parties did contemplate that. They didn't contemplate the fire hose technology or anything like that. That was not in use anywhere. Now, later we did use some of that to try to fulfill obligations under the pipeline. But on the pipeline, we believe is to be the scope.
So is your interpretation then of that language on the pipeline language in section 2 that it says Brigham may then use other water sources or pumpers on the pipeline? I think in answer to Justice Bland, you said that on the pipeline modifies pumpers, but it doesn't necessarily modify water sources, so that if Lindale's unable to provide water through the pipeline, Brigham could bring it in trucks?
If we're not able to provide water on the pipeline, or going, and that's why it uses through the pipeline here, you could go ahead and find other ways to do it, but it's undisputed that never happened.
But does it have to be on? Do the other water sources have to be on the pipeline, or if you choose to do it by, in other words, could you bring it in trucks, or is it just if you choose to do it with pumpers that you have to do it on the pipeline? What is the last on the pipeline model?
No, if it was on pumpers, certainly it had to be us, because we still had the exclusive right to do that.
Unless you couldn't provide it.
And we had provided the pumps, but not necessarily for the water providers, I think. Now,
Paragraph 4 begins with the phrase "all Brigham projects," and that's in paragraph, I guess, section 4, paragraph 1. All Brigham projects shall have first priority, et cetera, et cetera.
Yes.
The second paragraph talks about the sole and exclusive water provider and pumper on the pipeline. Why didn't it just say for all Brigham projects, so defined?
there's a good reason for that. There were a number of projects Brigham had. Remember, we had a previous arrangement with Brigham in which exclusivity was excluded, by the way, which is on the first page of our handout, and we insisted on exclusivity in the second one, but that doesn't answer your question. What does answer your question is this. Brigham had a number of other projects in this section of North Dakota. We were only on the Rough Rider pipeline. You will see in the brief on the merits, they try to say that our position is that we had everything with Brigham. It was only the Rough Rider project, and the preamble definition of pipeline decided that. Does that answer?
So if I understand, you're saying that then the second paragraph of section 4 basically means all Brigham projects that are on or connected to the pipeline.
Yes.
That's shorthand for that.
Yes. And it's important to note, if you will look at this, I put it as where does the water go? This is section 2A. 2A talks about where the water goes and how we get paid. And that is on page 3 of the handout. The important thing here is there was no secret where the water went. It was going to the wells. Now, Mr. Smith made the accurate statement that we didn't put it down the wells. We gave it to people who injected it down. In answer to the questions about pipeline appurtenance, well appurtenances, it's more than what they suggested. It's everything that there has to be tanks at the site of the well. You've seen pictures of those on public reports, 10Ks, and everything else that you see in the pipeline industry. It was that, it was tanks, it was pits, even where water could be done. But it had to be connected to the well to get it down. We provided that. And those are the things that are well appurtenances. And by the way, if you look at 2A, we don't get paid unless the water goes down the well. So we got to get it to the well. And the suggestion that somehow we are divorced from what happens at the well is just simply not right. We've got to get it there and go down. And again, if you'll take a look at page 3, and I put it, where does the water go? Brigham shall only be charged by Lindale for water that is pumped down hole.
So what's your response to their point that they didn't use any of your wellhead appurtenances to get their frack water from the lay flat pipelines into the wellbore?
What they're really trying to say, what that argument goes to, is what he said one time, but tries to get away from other places in the brief and in the argument. Their real position here is we have no exclusivity rights in terms of providing water. We only get the opportunity to be the operator and the pumper. That's why he emphasizes we could sell water to third parties. It's not at all true. We're sole and exclusive water provider on the pipeline. That's what we are. That's what we bargained for. That it was a complete change in the relationship between the parties to be able to get that kind of exclusivity, and that was terribly, terribly important to us. There's testimony, and I know this does not go to ambiguity. I'm not suggesting that it does, or whether it's ambiguous or not. But there's testimony in the trial we would not have done this deal. I mean, the real truth of the matter is we put $1.2 million up front into this project for a small Texas company like ours. That's significant. Initially, we had to build out more pipeline to be able to get the capacity right. You don't see them mentioning that. We do in our brief. At a total cost of about $8 million to be able to perform this contract. To do all those things, to provide the permits. Why did you get a permit if you weren't the water provider? Get a water permit. You had to have it. We got it. Second, we had to provide pumps. That's consistent with pumping, but you got to bring water under pressure on the pipeline. Everybody knows that. So the truth of the matter is the water was going to 2 points. The water goes to the well. We were the exclusive water provider on the Rough Rider pipeline project. That's the scope. Everything else deals with functionality or performance. Let me speak briefly to damages.
Before you get to damages,
yes, sir.
our court hasn't really taken a deep dive on requirements contracts since 1955, and that was before our legislature enacted the UCC. Does the subsequent enactment of the UCC change the requirements of showing that there's a requirements contract?
Not in this instance, although I would say that probably the UCC provisions would have changed the Pace Corporation versus Jackson case. I think it would have changed the result of that. But the consistency with San Jacinto River Authority, Pace Corp., Baylor County Utility District versus Seymour is all the same, and it's this. The court routinely enforces requirement contracts, as you should, and option contracts, as you should. We take the point that they weren't obligated to give us the right to, they didn't have to ask for any water from us. That's right. There's no doubt about that. But if they used water on this project, we were the sole and exclusive provider of water for it. That is very consistent with the holdings of each of these cases. In all three cases, it's important to note, there was one other common factor, and that factor was a significant amount of capital contribution had been made in the requirements contract. In Pace, it was a sale of stock and in exchange for exclusivity. There was a significant, in Baylor, a significant investment, $550 million building a plant. San Jacinto River Authority, same type of situation. It was all those kinds of things where significant investment made a difference. Exactly the same is here. We made a significant investment. Let me very briefly talk about damages. I'm going to say two things, although I suspect we're going to hear more in rebuttal I'm not going to get to respond to. But here we go. First off, they take pot shots at the question, the value question. It actually comes from PJC 114.5. It is something that is used normally in breach of contract cases. Why? Because generally for direct damages, what you have in a breach of contract is that you were promised one benefit and you didn't get it. They take on, well, you didn't put on evidence of difference. Yes, we did. If you're promised something and you don't get it, what you didn't get is the difference. And that's what this case did. They say it's lost profits, and in a sense they're sort of right because that's the way it actually was put on. And the question is, they say, well, lost profits and value can never be the same kind of thing. And they're completely separate. Not true. Formosa Plastics clearly said the benefit of the bargain damages can be lost profits. April Ferris's opinion in USPLS versus gas, which we gave to you yesterday in a handout, says that lost profits on the contract breached are direct damages, not consequential. That follows 5 other courts of appeals that had decided the same thing. But finally, and the big point is, Justice Hecht in Phillips versus Carlton Energy said you can prove lost profits by capitalizing lost income. Or excuse me, you can prove value by capitalizing lost income. That's the real world, that's the accounting world, and that's also the legal world. Thank you.
One other
questions, yes.
One other
Yes,
question on
please.
damages. What if you mitigate your damages? And there seems to be some argument here, well, there was more water for you to sell to other folks that you wouldn't have been able to sell to them if they had taken all the water they were supposed to take, and so you made some money on that, and why shouldn't that be subtracted out?
Good point, and let me answer the question this way in a very, very quick period of time. First off, the testimony by Mr. Houghton that is referenced in our brief takes on that we had adequate capacity to do it. That was one of their big points. But should it offset? No. Here's why. In the agreement the one we were just looking at, we retained the ability to sell water to others. In fact, one of our complaints was they didn't build the line large enough, the 12-inch rather than 6-inch that was in the contract rather than the 6-inch line, so we could do that.
And would
But-
you have the ability to do that? To have the contractual right to do it is different than having the actual ability to do that.
Let me be
given-
honest, it was their obligation to build it, not ours. So I don't know, there's no evidence in the record on that at all. But, having said that, the answer is the contract gave us the right for the profit from what we sold to Equinor and the profit we could get from other people after we paid Equinor what they were owed for us doing that, which was another jury finding that is not appealed and that we have accepted, roughly $3 million.
Any further questions? Thank you, Mr. Kellner. Mr. Smith, I believe you have 5 minutes.
3 points on rebuttal. First, Lindale just conceded that there is no evidence that the pipeline had the capacity to generate the full value that they say that they would have been able to derive. That is precisely our point. The amount of damages is not supported by the evidence in the record. Second, Justice Sullivan, you asked about the UCC. That is an important point because on page 9 of the respondent's brief, they concede that this is a services agreement, and they were even more explicit in their appellee's brief in the Court of Appeals, page 56, where they conceded that the UCC does not apply. This is not a technicality. It demonstrates that the purpose of this agreement was to provide the service of pumping and providing water on the pipeline, not selling water. It is not an exclusive sales agreement because, as they've said, the UCC does not apply. It is a services contract with respect to the contract itself. They talked about the purpose of the agreement. I want to point the court to the decision in Polyco, which emphasized that you can't take the purpose of a contract in order to rewrite the scope of the obligations. There are various ways to accomplish the purpose of providing water to an oil and gas well. You could create an option agreement. You could create a take or pay obligation. You could set a floor on the minimum amount that you have to purchase. Or you could promise to purchase it all. Jurors aren't free, and neither are courts, to take the purpose of an agreement and pick and choose among the ways of getting there when the parties have already tailored the way to accomplish it in the promises in the plain text. And this promise says that Lindale shall have sole and exclusive rights. It shall be the sole and exclusive water pumper or provider and pumper on the pipeline. Nowhere does it say for wells. I think it's telling that there was.
Well, they say it says the project. So what's your response to that?
The exclusivity clause does not say the project.
Well, they say okay, I mean, we can go back through it. They say the following terms have been agreed to with regard to the North Dakota Rough Rider freshwater pipeline project, the pipeline. Mm-hmm. So if the pipeline includes the whole project, they say that means it includes supplying water to the wells. And what's your response to that?
If you look at the definition, the rest of the definition, it explains what the project is. And the project is the pipe, and the project is the infrastructure. There's a way to have defined the project to include the wells themselves. They didn't. They talked about the map. The map does not expand the scope of the contractual obligations. Justice Bland, your decision in Occidental Permian talked about how you can have an attachment, Exhibit A to an agreement, used to identify what is talked about in the contract itself, but it doesn't change the scope of the promises. And to be clear, there are only 4 or 5 of the wells that they have in their damages model that can be found anywhere on that map. The vast majority of the 94 wells that they claim that we breached by getting water from someone else with respect to are nowhere to be found on the map. In fact, they were not even in existence yet. They were not part of this arrangement. Finally, I want to talk about the general fairness notion that was discussed. The truckers who were providing water by truck before the pipeline displaced them may have expected that they would be continuing to provide water, but they didn't have a contractual right to do so unless their water providing contract said so. In the same way, Lindale has can't complain that its technology has been displaced without an express promise to that effect. There is none in this agreement. Jurors are not free to pick and choose the best way to accomplish the purpose when the text already says so. It says sole and exclusive water provider and pumper on the wells. Or pumper on the pipeline. Lindale cannot be the sole and exclusive provider with respect to the very thing that we all know it was not the sole and exclusive pumper for. This court should reverse and render.
One other question. Mr. Keltner already gave us a disclaimer that he ain't write these briefs, and so I take that page 9 of the red brief says it's a services contract. What about the fact that Section 2B provides that the parties agree that Lindale will charge $1.35 per barrel for fresh water delivered through the pipeline for producing and so forth? Is that not we got a price for the molecules that are going to a purpose? Why is that then just a services contract?
So that is a component. This court in the 1980s adopted the dominant purpose test for when you have a contract that has mixed components, and when the dominant purpose is for services, the UCC does not apply. The dominant purpose for this contract is the service with respect to the pipeline itself, not an exclusive sales agreement as to wells.
Any further questions? Thank you, Mr. Smith. Thank you to all counsel. The case is submitted and the court will take a brief recess.
All rise.